Recently, the Supreme Court of India struck down the Electoral Bonds Scheme on 15 Feb 2024, saying that the Electoral Bonds Scheme is unconstitutional as it violates the right to information under Article 19(1)(a) of the Constitution. More importantly, the Supreme Court not only struck down the Electoral Bonds Scheme but also struck down the amendments which were made to implement that Electoral Bonds Scheme.
The Supreme Court has struck down electoral bonds. It has declared them unconstitutional.
Supreme Court today has struck down Electoral Bonds Scheme altogether.
The Supreme Court has struck down the Electoral Bonds Scheme.
Electoral bonds were the financial instruments that used to allow individuals and corporations to donate funds anonymously to the political parties. Electoral Bonds Scheme was the scheme under which these electoral bonds used to be issued by the specified branches of the State Bank of India. It was introduced in 2017 and it was successfully implemented in 2018. It was introduced to bring transparency in the political funding and curbing the black money according to the central government. Now let's understand how this scheme used to work and what were the features of that scheme. First, these electoral bonds used to be issued by specified branches of the SBI. It means that only authorized SBI branches were allowed to issue these electoral bonds. Second, these electoral bonds used to be issued in particular denominations such as 1,000, 10,000, 1 lakh, 10 lakh and 1 crore. Third, they used to be available for the purchase for 10 days in the month of January, April, July and October, with an additional time frame of 30 days in the year of general elections for Lok Sabha. Fourth, according to the provisions of the scheme, only legally registered political parties under the Representation of the People Act 1951 under Section 29A, which got at least 1% of the votes in the last election, were eligible to receive electoral bonds. Now let's understand through the practical example. For instance, suppose you wanna donate 10,000 rupees to your favorite political party. Instead of giving cash to the party, you will go to the SBI branch and you will tell the bank you want to donate 10,000 rupees amount to particular political party. And then that bank will issue the bearer bond and give it to you. Then you will give that bond to your favorite political party. Then that party will go to the bank and redeem that bond. And the specified amount of the 10,000 rupees will be deducted from your account. Within a span of 15 days of issuance, that electoral bond had to be redeemed. If the bond is not redeemed in 15 days, all the money used to go in the Prime Minister Relief Fund. Now you might be wondering why the Supreme Court struck down that electoral bond scheme. What was the problem with that scheme? When that scheme was implemented in 2018, the Union government had done some amendments in the Representation of People Act 1951, Income Tax Act, Companies Act, etc. through the Finance Act 2017. First, under the Section 29C of the Representation of the People Act 1951 required all the political parties to declare any contributions higher than the 20,000. The central government had amended that provision through the Finance Act 2017 and exempted political parties from making declarations of donations received through electoral bonds. Second, the amendment via the Finance Act 2017 to the Section 182 of the Companies Act 2013. This amendment removed the cap on the amount of money a company is permitted to contribute to a political party, which was set at 7.5% of its average net profits from the preceding 3 years. And removing this cap allowed unlimited contributions even by loss-making companies. The petitions were filed against the Electoral Bond Scheme from its implementation, and after considering all the arguments from the petitioners and the central government, the Supreme Court gave the final verdict. In a response, Supreme Court struck down Electoral Bond Scheme, saying that it is unconstitutional as it violates the right to information under Article 19(1)(a) of the Constitution. Court also said that the voters have the right to information about the political parties and their sources of funding, and unlimited contributions violate the right to free and fair elections, because that might increase the influence of the companies in the electoral process. And whatever amendments were made to these acts, they all struck down by the Supreme Court and restored to its earlier position.